Paul Harding from Martin Harding Mazzotti. Hey, Paul, how are you?
Good morning, guys.
We want to talk. There was a very interesting, I guess, but narrow ruling this week by the U.S. Supreme Court on Facebook threats. Long story short, this guy, bad guy in Pennsylvania, I guess his estranged wife, he made threats, what sound to me like threats about he's going to maybe kill her and stuff like that. But the high court said just because you're afraid doesn't make it necessarily illegal.
Yeah, I'm glad we got to talk about this case again because it's been working its way through, and I think that there was a lot of confusion around it. Supreme Court came down and said, hey, what we don't want is just rants and threats on Facebook that don't really have, or anywhere, but don't really have any true substance to them, and we're not looking at the mental state or the intent of the person to be a crime. So in this case, they said, hey, we don't like anything you said, and certainly offensive in any category, but what we need to do is the jury has to consider the mental state or intent of the person saying it and the circumstances by which they are in a position to even do something. So the Supreme Court doesn't look like they're not soft on crime or soft on these type things, but they just don't want this thing to get away from them.
So the guy posted there's one way to love you but 1,000 ways to kill you, and that wasn't considered to be threatening?
Well, interesting. Their argument there was that, hey, remember Eminem, the artist, and he always had trouble with his wife, and he'd talk about drowning her, and they sort of equated it to that. It was just sort of a rant. He was just sort of poetic in some regard, I guess. And they found that although offensive words, that his mental state was one of just sort of blowing off steam. At least that's what a jury would be able to consider now, not just how they would interpret it, but where he was, in life, his mental state, his intent, before they could convict. Not as if they couldn't convict on this, but they need to consider more than they did in his conviction.
It's interesting. This is the direct opposite of sexual harassment, where it's not the intent, it's how it's perceived, where that is the definition.
Good point.
Right. Well, again, that was the rule up until the Supreme Court decision was how these threats were perceived, and the Supreme Court saying it's just not enough. And I really think social media did make a play here, because if you're going to go through and look at what people are posting, every second by second, and someone says, well, I'm going to kill him and he's this and he's that, they just didn't want to deal with it, and they wanted the juries to have to dig a little bit deeper than just reading those words on a post or even however else they're distributed.
Yeah, I get that, and I'm a free speech guy. It just seems to me it's awfully hard to, unless somebody has a cache of weapons and a map to your house, it's sometimes impossible to determine whether you're serious or not, what your intent is, Hey, real quickly, there was another ruling involving this woman who said she was discriminated against by Aber&Fitch, a Muslim woman who showed up for a job interview with a black headscarf. What was the finding on that?
Once again, the Supreme Court came down sort of where I thought they would. They said, hey, you can't discriminate against someone for their religion, right? We got the Civil Rights Act and we got the Constitution there. But what they did, it was really kind of unique, and it's going to affect employers all over the place, is that it puts the burden on the employer to sort of ask the question. She comes in with a headscarf, and you have to say, hey, listen, in this case, Abercrombie said, well, we would have let her work. Had we known she wanted to wear it, we just would have had her wear maybe a pastel or sort of a covered scarf, was their argument. And the court said, look, you need to ask those questions, employer. You just can't sit back and presuppose things. So they found that they did violate the rules, and it is a really big day, I guess, for the folks who are going to come to a job interview as they are and not have to hide their religion, hide other parts about them. So the courts are going to find this, I think, consistently now, and I think that we're going to see more and more of these cases pop up.
All right, interesting stuff. Paul Harding. Thanks so much, Paul.
Okay, guys, thanks.
Paul Harding, Martin Harding Mazzotti, 1-800-LAW-1010.